Got about another minute here or so till 10 o'clock. We'll let everybody meeting, and then we'll start here in just a minute. Okay, it's 10 o'clock. We'll bring this meeting to order. Special called meeting August 3rd, 2020 of the Glasgow Electric Plant Board. This meeting is now in order. Got two items on the agenda for today. Number one is election of officers. Number two is reconsideration of external counsel for EPB. So before we begin, we can consider the second motion today. First motion, as chairman, I'm going to refuse to recognize the first item on the agenda due to it being dilatory, absurd, or frivolous. It is contrary to state law. We do not have any indication as to term limits for board members, and it has always been our customary for us ever since I've been on the board anyway, and as far as I can see back, that board members' terms are consistent with their terms on this board. Under the scenario that's been proposed during this special meeting, we could conceivably have new members elected as officers every meeting, and again, that's absurd and both frivolous and absurd. So we're going to stick with what has been customary, long-standing precedent. It is my opinion that the officers' terms run with concurrently with their terms on this board. So in absence of any other law indicating otherwise, we're not going to recognize the first motion. So we can move on to the second motion as reconsideration of counsel. If anybody would like to bring that up as a motion to consider.
I would point out that the board is run by a majority, and there are no rules that supersede the majority of the vote on the board. This is a special call meeting to elect officers, and what you're doing, even though you can suppress the vote, is not legal.
Okay, your objection is noted for the record, DT. Thank you.
Hey, Tag.
Yes,
can you hear me?
Sure.
I just want to be sure and be clear, because I know this question has come up a couple of times. And of course, the statute says the board does establish their own policies and procedures. So I was trying to look just to see, what TVA, there was some mention, I think, in the past by Billy Ray about maybe we sort of quasi-adopted the TVA bylaws, because we don't really have any bylaws. This did come up in January or February. I think it was on the February meeting. I think at that time you mentioned something about what you're saying now, the law, because there's not any expressed term. But the the TVA laws are that for board chairman, they're elected for 2 years, but then it says unless the board decides otherwise. So I think they have discretion to do what they want to. But based upon Billy Ray's comments back in February, he does confirm that there's never been a policy about that as far as election of officers, and was recommending one at that time, which I agreed with him. I think that was a good idea to have elections. So I don't, I'm not sure what you're citing to. Obviously, I would agree with DT that as the chairman, if you don't let it come in, it didn't come in, whether that's right or wrong. But I don't think there is a policy. The only comment I guess I would make, just so the board's aware and everybody realizes, the last chairman was DT prior to UTAG, and he's been on the board the entire time. So maybe that's just never been questioned. But I just want to be sure all the facts are thrown out there for you guys to consider. when you're making that decision.
Right. Thank you, Ronnie.
Well,
yeah,
it would not to interrupt you,
go ahead.
Mr. Chairman, but it would seem to me that in order to eliminate all this confusion, it might be a good idea for this board to actually put some type of policy in place. That way we don't have to go through this all the time just because there is no policy. That would make sense anyway.
Yeah, again, I think, erring on the side of caution, absence of any procedures, even internal procedures that are explicitly state what our term limits are, et cetera. I think it's best to go ahead and err on the side of caution. Not appreciate it. So we can move on to item number 2 on the agenda, election of officer, or I'm sorry, the reconsideration of external counsel.
I make a motion that the firm of Cole and Moore be removed as legal counsel for the Glasgow Electric Plant Board.
I would second that motion.
Okay, so we got a motion and we have a second. Any discussion? Well, if nobody else gonna say anything, I guess I will. Legal representation is a cornerstone of our judicial system. It seems to me that Libby and I, working in our capacity as members of this board, what I would like to say is the opposing side, I guess, is now attempting to remove legal representation from the side that is being represented in their capacity as board members. And if we can review, I think everybody will understand and remember that we now have an open question before the court under reconsideration by circuit court. This all stems from a lawsuit that was brought on by and requested by D.T. Froge against 2 members of the board, which are now this item is still before the court. Still has not had a final decision made. And now the opposing side is wanting to remove counsel and legal representation from the other side that has been sued by a member of the board whose question about his viability as a board member is still before the court. So is that what I'm hearing you bring up here, DT, today is in the form of a motion?
I'm pointing out the fact that this firm has gone into court without authorization of the board and advocating positions that are not consistent with motions of the board. The board has not acted. This firm has acted for the purpose of 2 members against 3 members, and they do not have authorization. There's been no vote to allow them to go into court, and what they're doing is unethical.
Well, we can let you take that up with the bar association, DT, but we are entitled to defense in our capacity as board members from outside lawsuits. That's part of public members' defense. So you are entitled to go into court for any reason, as am I. In my case, I'm paying my lawyers, and you are allowing the Glasgow Electric Plant Board to pay yours. This is on the part of an individual. It is not. You're the one that brought the suit. You're more than welcome to engage your own counsel, and we are entitled to defense in our capacity as board members.
I'm a board member too. I've always been a board member.
You were a board member, DT, but you are not the respondent in the case. You're the plaintiff in the case. So there's a difference there. So we are entitled to proper defense.
And the board's authority is being used without authorization.
Well,
the board never voted to defend you in court.
Well, DT, we have voted back in 2017 to engage this law firm for an item that was germane to what we're currently dealing with today. It's all part of the same deal. That's why they were brought back into this
my court action was not against you. It was against the board. And the board has never acted to oppose that.
DT, that's incorrect. My name and Libby's names were specifically included in the suit, in the complaint. So that is not correct.
I call the question.
Question's been called, and everybody remember, we've got another hearing coming up on the on Thursday, the 6th. So, you know, I believe most of this will be taken care of at that point in circuit court. So we'll I guess have a final determination, or request for a final determination on whether or not we're entitled to proper defense to a complaint lodged by a member of the public. In our capacity as board members. We take the position that we are. I believe the law is going to take the position that we are entitled to that proper defense under current law. So, but the question has been called, so we'll call for a vote.
Wait a minute, just so everybody listening has this straight. We have been sued in our capacity as board members, of which we are entitled to representation. But yet DT brought that suit against us, but now he wants to strip us of our counsel.
That's the way I see it.
Just so everybody watching, I mean, that's, well, I guess, well, let's go ahead. Y'all got the votes to do what, y'all got the votes to do what you want to do, but that is just such a.
I think that the actions of the chairman caused DT to have to file that lawsuit, you know, because that's the way
Glenn, I understand that. But
Tag, try to get them to talk one at a time, would you? I mean, I think it'd be better for everybody.
Sure.
Go ahead.
Harder with this Zoom to take turns.
Yeah, Glenn, are you finished?
Well, I'll repeat it because I don't know where I got to, but I think I said the actions of the chairman caused DT to have to file that lawsuit. And he felt like he was a member. Obviously, the chairman felt like he was not. So, you know.
No, I understand very well what
that's all I'm saying
about. But I'm just saying that as board members, we are entitled to representation. And for somebody to want to come in and strip us of our counsel, I mean, that's just, I'm sorry, I'm just going to go ahead and be blunt. I mean, that's just a punk move, in my opinion. I mean, that's just the way it is. We're entitled to counsel. If you're sued as a board member, Glenn, you're entitled to that same counsel, honey. That's the way it works.
Dangerous precedent that you're going to set right here today.
Question.
Stripping away the potential for your own defense in the case of a suit. So, you know, in reality, anybody could turn around and sue any of you and name any of you in a suit at any time from this day forward. And you would be responsible under the current proposal. You would be responsible for your own defense in your capacity as a board member. So I don't think we want to open up that can of worms. Marlon, that would be true for you as a city council member. Glenn, that would be true for you as a member of this board. DT.
Because I mean, at the end of the day, it wouldn't even have been a question. DT wouldn't have even had to go hire his own lawyer if he had simply just showed up to meetings and done what he was supposed to do.
So I caution you to set this precedent today, because it's going to open us all up, many of you, to potential liability. Even if it's favorable outcome for you in your hearing, whatever potential hearing that may be, the cost of defense of that could put you into grave financial peril. So I warn you against opening up this can of worms today. But the question has been called, and we'll now proceed to a vote.
What, can you repeat the question, please?
Yeah. So, DT, would you like to restate your motion, please?
I move that the firm of Cole and Moore be removed as legal counsel for the Glasgow Electric Plant Board. Hey, Ronnie, I'm going to open this back up for discussion, but while we've got this, why don't you tell us the ramifications to each individual board member under the terms of DT's motion today?
Well, I think the board, when the board, in your capacity as a board member, I would think the EPB would have an obligation to protect you. I know that, I think I saw some letter from the insurance carrier for the board members that they were not covering that because there wasn't any specific damages sought, if I'm correct about that. I mean,
That's
I think
correct.
you got a letter about that. I think the real question becomes when Cole and Moore file motions. I think that the one motion that I saw was to not allow any special meetings. Maybe that's going away. I'm not sure. Obviously, we're in a special meeting here, but that would be contrary, obviously, to the majority of the board. So I don't know how an attorney can represent a client and then go against that client, which operates by majority. As far as just the representation of a member as a board member, then I think you are going to have some outside counsel about that. The problem being with that, where it puts that particular counsel as, is which position they're advocating. It's obviously they can advocate on behalf of you and Libby being a board member in your capacity as a board member, I think. And I don't know how they were employed the last time, back in 17. I think I've heard that date, and that may have been when you had I'm gonna call it an outsider. That was when the city council, I think, was attacking the whole board, trying to remove it. That's when that took place. But I think certainly the council members are entitled to representation in their capacity as a board member, to be covered under their position as a board member. But I think the council, and it may be more a question that more of them have to answer as to how you're going to take a position contrary to the actions of your client when they say they're representing the EPB.
Okay.
So in other words, what you're saying then is DT can sue us as board members. However, we have to have DT sign off on who is our attorney. Come on.
No, I'm not saying that, Libby. But I'm saying if you're acting, if you're taking the position as the board, then the board acts by a majority. If you don't like the position of the majority, then you're in the minority, and that's just the way this board works.
No, I'm very well aware of how the board works, Ron. I'm just saying that it's just ironic to me that we're sued as board members, but yet we're going to have to turn around and let DT approve who our attorney is or vote on it. That is ludicrous. Bottom line, ludicrous. But I guess whatever works to accomplish your means. Let's vote.
Well, I think what Ronnie is stating, and Ronnie, let me see if I've got this straight, but you're basically stating that that Cole and Moore cannot hold themselves out to representing the board. They can hold themselves out to representing Libby and I individually as respondents to the lawsuit, right? And we will be entitled to that proper representation that shall be supplied by and paid for by the electric plant board in our capacities as board members. Is that what you're saying, Ronnie?
I think in your capacity as a board member, they should be able to represent you as a board member.
Okay.
I think where the trouble comes is because it's an internal conflict within the board as opposed to an outside entity or person or whatever trying to attack the actions of the board. This is more of the board members fighting, but I certainly think the board members in their capacity ought to have the right to have representation, employed by the EPB. Right,
and even though the extension of those
council's got to be careful in taking whatever position they take as far as I guess what would be an act of the board. Yeah.
So these are valid questions that have been before the court that are acting in capacity as the entire board. It affects the entire board along with the customers and the citizens of this community. That doesn't necessarily make it wrong in the fact that if someone feels like there's been an illegal act or an act of malfeasance or misfeasance by, even if it is the majority of the board, that legal representation is not available to them in their capacity as board members. And if that particular action that's being questioned is considered to be illegal in some form or fashion, then that even if it's the minority of the board that feel like those actions are illegal, those actions should be responded to through legal representation that represents not only the individuals that feel the actions are illegal, but in capacity as the board in representation of this entity and the citizens of this community. So again, I think we're setting a very dangerous precedent by bringing this up. I think we're opening ourselves up, all of us up, to substantial legal liability when it comes to representation from proper counsel. So I really caution you in doing this today that the long-term ramifications and consequences of this will be far-reaching for all of us and for many years to come if we let this happen. You're really going to be putting yourselves and all of us in jeopardy. I've got a few months left on this board. Not going to affect me as much as it is the rest of you. But I can assure you of this. If you let this go through today, you're going to open yourselves up to many, many problems. People are going to jump on top of this like you've never seen anybody jump on top of things before to try to influence you and try to run you out of your position on this board. So anyway, question's been called. Let's go ahead and have a vote. All those in favor of removing Colin Moore as counsel, please signify by saying aye.
Aye.
All opposed, like sign.
Hey, I think you're gonna have to stop the meeting because DT has disappeared.
Yeah, you gotta hold off.
Okay.
Lo and behold.
Really, he'll try to reconnect. Yeah.
I'm getting a
He's still on there, isn't he? It's just on.
oh.
There's DT coming back.
Okay, DT's back
Sorry
in.
about that. My internet just dropped out.
So we were taking a vote, DT. So question's been called. Bring it to a vote. All those in favor of removing Colin Moore's representation as EPB counsel, out the external counsel, signify by saying aye.
Aye.
All opposed, like sign. Aye. Motion passes. Okay, so that's the last two items on, the only two items on the agenda today.
Ronnie, I would like to ask how, if the council can represent a board member against another board member, are both sides entitled to representation or at least funding by the board?
Well, it makes sense that they would be, but because I think, so far the board's been unable to vote on any of these actions that's going on, of course. I don't know why one member would be treated differently than the other when it comes to that representation. I don't know if you or anybody's checked into the coverage that's available, just like I guess TAG, and I'm not sure how that question got there. TAG maybe can answer that I saw the memo about not covering this particular action, the initial action. Now, I'm not talking about the other actions because there's been another firm, I think, that has indicated they're there on behalf of the errors and omissions policy. Is that, but I don't think they've really taken any action yet at this point. So.
Yeah, so anyway, we've called the question, we voted, discussion's over. I'll entertain a motion to adjourn.
Motion.
All right. Motion
I
is,
second that one. So
all right,
we are something actually important today.
we are adjourned. Thank you very much.